Welcome to Debt Matters. When a business decides to outsource its debt recovery, well, they're not just handing over a list of names and numbers.
No, not at all.
They're outsourcing a really critical part of their cash flow engine to a third party.
That's a perfect way to put it, the cash flow engine.
And if that engine suddenly, seizes up, if the collections agency itself just collapses, the fallout is immediate. It hits everything from your balance sheet to your regulatory standing.
Everything.
So our focus today is on a very specific, real-world situation in the UK market. We're looking at the case of Mears Credit Services.
Right.
They recently went into administration, which forced this immediate and really complex transfer of collection rights for a portfolio worth over £20 million.
A huge amount.
It really is. And it gives us this detailed look at the kind of operational safeguards you need to protect an asset during a crisis like this. So this analysis is really for you, whether you're managing this kind of outsourced risk, or maybe you're one of the parties who's actually affected by a transfer like this one.
And there are many.
Exactly. Our goal here is to pull out the actionable sort of technical clarity that UK businesses need to protect recoveries, and just as importantly, to navigate the really dense compliance rules that pop up the moment a partnership like this ends so abruptly.
And that abrupt ending, that's the key. That's the operational flashpoint.
Right.
When an agency that's handling millions of pounds of someone else's money just fails, the stakes are incredibly high. For the creditor, the company that's owed the money, the value of that debt book, and it is a tangible asset, it's suddenly at risk.
It becomes volatile.
Instantly volatile. And they need swift, precise, and highly compliant legal action to preserve those future revenues.
But it's not just about the company's books.
No, absolutely not. The focus isn't just internal. You've got thousands of individual debtors who are suddenly thrown into confusion. They need legal and regulatory certainty.
Who do I pay now? Is this even real?
Exactly those questions. The whole integrity of the process and the protection of consumer fairness, it all has to be maintained under the UK's really stringent financial conduct rules, even when the service provider has, just ceased to exist.
So we're going to look at both sides of this.
We have to. We'll cover ensuring cash flow continuity for the creditor and then maintaining that absolute regulatory precision and consumer protection for the debtor.
Okay, so let's ground this in the specifics of the event itself, because the scale here really dictates the urgency.
It does.
We're talking about Mears Credit Services, an Essex-based firm. They entered administration in September 2025, and this wasn't some gentle, planned wind-down.
Oh, it was a cliff edge.
It was a sudden insolvency. The administrators had to take immediate control.
Right.
The outcome, which did preserve the recovery potential, was a transaction managed by Begbies Traynor, a Surrey-based firm, Redwood Collections, acquired the rights to collect on a debt portfolio valued at over £20 million.
And that number, 20 million, is the headline. But the detail is where the complexity lies.
For sure, because this wasn't a small-scale transfer. This one transaction involved stabilizing future collections for 178 different clients.
So 178 original creditors.
Exactly. And it affected approximately 3,725 individual debtor accounts.
Wow.
The operational mechanics of moving that volume of data and ensuring accuracy across almost 4,000 unique ledgers, it's immense. And that's why this case is such a valuable learning opportunity.
It absolutely is. And the first principle this whole situation establishes is just critical for any finance department to understand.
Which is what?
A debt book isn't just a spreadsheet of unpaid invoices. It is a demonstrable, saleable asset.
Right. There's a value.
A realizable value. So when a collections firm goes into administration, the administrator's primary legal duty is to maximize the value of all the assets for the benefit of the firm's creditors. And in this case, that means stabilizing and selling the collection rights.
Because if they just abandoned it,
If they just walked away, that £20 million nominal value would degrade almost instantly. The original creditors would have to try and bring all those accounts back in-house, find a new agency.
all while losing valuable time.
Precious recovery time. So by selling the collection rights, the administrator is essentially transferring the operational machinery needed to get value from that asset to a new functioning company, which here was Redwood Collections.
But the nominal value of £20 million isn't what the acquirer, Redwood, would actually pay for it,
yeah.
is it? We always hear about debt being sold for, pennies on the pound.
A very good point.
How much does the quality of the data, that operational integrity you mentioned, affect the price in a situation like this?
That is precisely the connection we need to make. The sale price of a debt portfolio is based on its estimated recoverable value, not its face value. So, if the records from the defunct agency from Scott and Mears were incomplete, or they were missing original contracts, or, and this is a big one, they failed to accurately flag disputes or vulnerable debtors,
Then the value plummets.
it plummets instantly. An acquirer like Redwood Collections has to factor in a deep discount to cover the legal and operational risk of collecting poorly documented debt.
Can you put a number on that?
Well, think about it. For a £20 million portfolio, if the administrators couldn't provide clean, auditable files for even 10% of those 3,725 debtors, that could translate to a multi-million-pound loss in value before a single collection call is even made.
Just because of bad data.
Solely due to data contamination. The sale is an immediate stabilization of the asset, yes, but the price reflects the risk profile that's being inherited.
And the choice of Redwood Collections, the fact that they're an FCA-regulated firm, that plays directly into that risk profile, doesn't it?
Absolutely. The FCA regulation is paramount, especially if there's any consumer debt involved.
Which there almost certainly would be in a portfolio that large.
Almost certainly. The acquiring firm inherits the entire regulatory burden. If Redwood is acquiring the debt, or just the right to collect it, they have to immediately show they can operate within the FCA's very stringent conduct rules.
And that's not just a box-ticking exercise.
No, it's a necessity. It's fundamental to maintaining the recoverability of the asset. Any firm that tries to collect on a regulated consumer account without the right FCA permissions or without following the rules on data integrity and fairness, they'd face immediate sanctions.
And that could even make the debt unenforceable.
Potentially, yes. So the transfer isn't just financial, it's a transfer of profound regulatory responsibility. And the administrators have to manage that to ensure they get the maximum value. The key, as you said, is continuity. And that continuity relies completely on auditable, clean, and compliant files.
Okay, this is where the rubber meets the road for all those UK businesses that relied on the defunct agency. You've outsourced this function, but now the crisis is right back on your desk. The moment you get that notice that your collections partner is in administration, how do you stop those files from becoming unusable? How do you protect your share of that £20 million?
Right.
We know collections are only viable when the underlying file is, for want of a better word, pristine.
Yes, that's the word for it.
So we've broken this down into 4 critical actions, starting with what sounds like the most difficult logistical step: verifying all the numbers against your own records.
It is the most resource-intensive action, but it's mandatory. The creditor has to immediately execute a full, comprehensive reconciliation of the schedule they get from the administrator or the new agency.
And that means matching every single account.
Every single one. All 3,725 in this scenario back to the creditor's own internal ledger systems.
But is that even practical? We're talking about a crisis. Is it realistic to expect a finance team to manually check thousands of ledgers when their main source of information in the agency just collapsed?
It is deeply impractical, you're right, but it's also entirely non-negotiable from a legal and compliance standpoint.
Why? What's the risk?
The reason is, in the details you have to verify. You can't just match the account name and the total balance. That's not enough. The reconciliation has to verify 4 specific components to ensure compliance and stop future disputes in their tracks.
Okay, so what are they?
Component 1, verification of the principal amount, the original undisputed amount that was owed. Component 2, the exact interest and charges position. You have to confirm that any interest applied follows the original contract and any relevant laws, like the Consumer Credit Act.
So no made-up charges.
Any excessive or non-contractual charges have to be found and removed immediately.
Okay, let's start.
Component 3, any fees incurred by the defunct agency during their collections process. You need to know which of these you can actually recover from the debtor and which are just internal costs you have to write off.
And the 4th.
And component 4 is the most volatile. All payments received right up to the point of transfer, plus any specific dispute flags on the account.
That 4th one sounds like the real logistical nightmare.
It often is.
I mean, if a debtor made a payment through the old agency's website 24 hours before they went into administration, that payment might be in their system, but not yet reconciled to the creditor's ledger.
A classic scenario.
What's the consequence of missing that crucial 48-hour payment window?
The consequence is collecting an overage, which is not only illegal, it's explicitly prohibited under the FCA's Consumer Credit Sourcebook, or CONC.
So you're chasing money that isn't actually owed.
Exactly. If the new firm, Redwood, starts collecting an amount that's higher than what's legitimately owed, the original creditor is ultimately liable for that regulatory failure.
And that opens you up to all sorts of trouble.
Immediate claims of unfair treatment, regulatory censure, maybe even compensation orders. The reconciliation process stops you from chasing ghost debt. You have to assume the data you get from a collapsed agency is tainted until you prove otherwise.
Okay, so once you trust the numbers, the focus shifts to the legal side. For those nearly 4,000 debtors, who exactly is legally allowed to contact them and ask for payment?
Exactly. And this depends entirely on how the collection rights were transferred. Creditors have to understand the legal authority the new agency has, which means distinguishing between two possible scenarios under UK law.
What are they?
Scenario 1 is a simple agency agreement. The new firm, Redwood, is just collecting the debt on your behalf. The original creditor still owns the debt completely, and the new firm is just a mandated agent.
That sounds simpler.
Legally, it's a bit simpler, but the creditor keeps all the regulatory liability for what their agent does.
And scenario 2.
Scenario 2 is a legal assignment, or a sale. This is really common in administrations because it cleans up the balance sheet. Here, the ownership of the debt itself is legally transferred from the original creditor to the acquiring firm.
And that's where things get more technical.
That's where the crucial legal detail of perfecting the assignment comes into play under the Law of Property Act 1925.
So if that £20 million portfolio was legally sold, why isn't the transaction agreement enough? What specific action has to be taken to make that assignment perfected in the eyes of the law? And what happens if you miss that step?
If it's a full statutory legal assignment, the law is crystal clear. Express notice in writing must be sent immediately to the debtor.
This isn't just a courtesy then.
It is a statutory requirement to perfect the assignment. The notice of assignment has to clearly tell the debtor three things: the name of the new legal owner, the fact the debt has been formally assigned, and the exact date from which they are now obligated to pay the new owner.
And if that notice isn't sent, or it has a mistake in it?
If that formal notice, and it's often a standard, but very meticulously worded letter, isn't sent, the assignment is only considered an equitable assignment.
Okay, equitable assignment. What does that actually mean?
Well, it still transfers the underlying rights, but it means the new collector's power to enforce the debt is weaker. Crucially, without that perfected statutory notice, the debtor might still legally pay off their debt by paying the original, now defunct agency or its administrator.
So the money could go to the wrong place.
Creating total chaos. It puts the debtor and the new owner at risk. The creditor has to make sure this notice is issued correctly to all 3,725 debtors, or the recoverability of the whole portfolio could be challenged in court.
So we've confirmed the balance, we've confirmed the legal authority. But none of that matters if, say, 6 months down the line, a debtor challenges the collection in court and the new firm can't provide the underlying proof. This is where the documentation pack comes in.
Indeed. Action 3 is securing the comprehensive documentation pack for every single account. This is the bedrock of enforceability.
And you have to do it fast.
The moment an agency collapses, their IT systems are sealed. The creditor's immediate priority has to be working with the administrator to get this evidence out before it gets locked away in the defunct firm's internal affairs.
What exactly needs to be in that pack?
It needs to be exhaustive. For a regulated consumer debt, the pack has to include the original signed contract or clear evidence of the agreement's terms, all the relevant invoices, proof that goods or services were delivered.
Okay.
The most recent statement of account, the complete detailed communications log, every call, text, email, and letter, all the correspondence about any previous disputes, and any record of forbearance or settlement agreements.
That complete communications log? That sounds like the hardest piece to get. It lives inside the old agency's own CRM system.
It is.
And if the administrator is focused on selling assets, they might not see extracting granular data for nearly 4,000 accounts as their top priority. So how does a creditor force that to happen quickly?
You don't really force it. You rely on pre-existing rights and the administrator's own need to maximize the asset's value. You point to the contract the defunct agency had, which obligated them to keep auditable records.
But in reality,
In reality, if the creditor didn't have a regular data export mechanism already set up, they're at the mercy of the administrator's timeline and budget. If the administrator has to spend resources to pull that data, they will charge the creditor for it.
so it adds another unexpected cost to the crisis.
Exactly. But the rationale is simple. Clean files recover faster. If you're missing the original contract or evidence of a dispute resolution, that debt becomes a weak claim. It is far cheaper to pay the administrator to extract the data now than it is to absorb the inevitable losses on unrecoverable accounts later on.
Let's talk about conduct. With a transfer this big, the focus shifts from just accounting to human treatment. If that £20 million portfolio is mostly consumer debt, the FCA's Consumer Credit Sourcebook, CONC, really dictates the new reality.
It does.
How does the creditor ensure that the new agent, Redwood, sticks to these conduct expectations from day one, even while they're trying to integrate thousands of new files?
This is where the creditor's residual liability is at its starkest. You appointed the agent, so you're responsible if they breach CONC.
So what's the first step?
The first mandatory action is setting up a clear communication plan. The tone, the cadence, the channels. You have to ensure the new firm adheres to strict CONC expectations. For example, CONC limits contact frequency and timing, so you can't just call people repeatedly at all hours.
And what are the biggest non-financial data points that have to migrate accurately? It's more than just the payment history, isn't it?
Oh, far more. The second critical protection point is all about social and regulatory data, vulnerability markers, and active dispute notes.
Explain that.
Of those thousands of debtors, many will have been previously identified as vulnerable, maybe due to mental health issues, a job loss, bereavement. The defunct agency was obligated under CONC to mark and treat these customers with sensitivity, often leading to things like forbearance.
And those markers have to carry over.
They must migrate accurately. If the new collector pursues a vulnerable debtor aggressively because that flag was lost in the data transfer, the original creditor is open to severe regulatory sanctions and huge reputational damage.
So you have to pause collection in some cases.
Pursuit of payment must be immediately paused or significantly adjusted for vulnerable cases or for accounts that are under a formal dispute. If the previous agency agreed to a 6-month payment break, that agreement must be explicitly honored by the new firm. You're basically mapping a complex set of existing moral and legal obligations onto a new system. Now, let's shift our perspective completely. Let's look at the 3,725 individuals who suddenly get a letter saying their collections arrangement has changed because of an administration.
Their first reaction must just be confusion.
Confusion compounded by a fear of scams. They're asking, who do I pay? Is this real? Should I have paid Scott and Mears last week?
So what should they expect?
They should absolutely expect to receive a letter or an email that states clearly that collection is now being handled by a different firm. Ideally, this notification is prompt. It mentions the administration, and it says whether the debt was sold or if the new firm is just an agent.
But there's a risk there.
A huge risk. The challenge is that administrations often cause an administrative lag, maybe a week or two, where information is volatile. And that creates a perfect window for fraudsters to launch phishing attacks using the news of the agency's collapse.
That administrative lag is a terrifying thought for a consumer.
Yeah.
So how can we empower those debtors to protect themselves without just telling them to stop all payments, which would hurt the creditor's recovery?
There are essential verification steps they should take.
Right. We would urge debtors not to tell anything based on a new message until they have proactive, written confirmation of 4 specific pieces of information from the new collection firm.
This turns them into their own compliance gatekeeper.
Exactly. First, they need the balance breakdown. This has to separate the principal from every single charge, interest component, and fee. The debtor has to check this against their own records to make sure no unlawful charges were added. That transparency is a legal right.
It is. What's the second thing?
Second, they need the identity of the original creditor. This is the non-negotiable anchor point. If you owed money to Utility Co. A, the letter must confirm Utility Co. A as the source. It confirms the debt is legitimate.
Okay, that makes sense.
Third, they must know the identity of the firm collecting Redwood in this case, and the specific legal basis for their authority. The why. Was the debt sold, or are they an agent? If it was sold, the debtor should demand to see a copy of that formal notice of assignment we talked about earlier.
Good. So they're checking the legal paperwork.
And fourth, they need a clear, established process for disputing the debt. If the balance looks wrong or they had a forbearance agreement, they need an accessible way to lodge a formal complaint or dispute the accuracy of the transfer.
And tying this back to safety, the most crucial instruction for the debtor is independent verification.
Yes.
If the letter or email seems at all suspicious, if the contact details look generic or the language is aggressive, the debtor has to pause payment.
And what?
They should then verify the information using known, independently sourced contact details for the original creditor, the company they first dealt with.
Not the details in the new letter.
Never the details in the new letter. This step bypasses any potential fraud entirely. You're confirming the transfer directly with the utility company or the retailer who originated the debt. It empowers the consumer and protects the integrity of the whole process. The operational lessons from this £20 million portfolio collapse are pretty clear. Relying on hope that your collections agency will stay solvent is not a risk management strategy.
No, it's a gamble.
It is. For any UK business that outsources debt recovery, you have to build an agency failure playbook before you need it. Waiting for the administrator to call puts you in a reactive, expensive, and non-compliant position.
And this playbook isn't about avoiding the crisis, because you can't always do that. It's about having the pre-negotiated infrastructure in place to turn an insolvency into a managed data transfer.
Exactly. Proactive operational continuity planning.
So let's detail the 4 mandatory components of this playbook that every creditor should probably implement immediately.
Okay. The first component addresses the immediate danger of data lockdown. When Scott and Mears went into administration, their servers were likely sealed off. The best way to mitigate this is through structured data security, like data escrow.
Data escrow. Break that down for us.
Data escrow isn't just a backup. It's a secured operational ledger held by an independent third party. This third party holds a continuously updated, clean copy of all your active debt accounts, the full documentation, the comms logs, the vulnerability marker.
And how do you get access?
The escrow agreement specifies a legal trigger event, like a formal notice of administration. That trigger automatically releases the most recent, full copy of the data directly to you, the original creditor. It bypasses the administrator's bureaucracy completely.
That sounds great, but probably also resource-intensive and expensive. If a full escrow isn't feasible, what's the mandatory minimum a creditor should demand?
If escrow is too complex, then the creditor must demand regular, highly standardized data exports. At a minimum, that means a monthly, full, auditable data dump that lets you recreate the ledger internally if you have to.
And that export needs to be detailed.
It has to be machine-readable and contain every granular data point we've talked about, the 4 reconciliation components, plus all the relevant CONC markers. That regular export is your insurance policy against a sudden, complete loss of access to your own receivables data. The second component needs to be written into the master service agreement with the agency. Creditors must demand clear, specific, and stringent termination and handover clauses that specifically address insolvency.
Because most contracts probably don't.
Most contracts detail termination for poor performance, but they're often totally silent on administration. Your playbook needs contractual language that specifies the immediate operational requirements after an insolvency event.
Like what?
Like mandated immediate access to the agency systems for auditing and data extraction, all within a narrow, specified time frame, say 72 hours, overseen by the administrator.
And who pays for this emergency migration? When the administrator steps in, their goal is to maximize the value of the defunct firm, which often means charging for every service, including data extraction for former clients.
Precisely. The contract must predetermine that cost allocation. Creditors should demand clauses that mandate the collection agency or its successor administrator provide the final data export in the agreed format at their own expense or for a pre-agreed flat fee.
So you're not stuck haggling over fees during a crisis.
Exactly. It's a pre-negotiated roadmap for a crisis exit. It prevents the creditor from getting stuck in prolonged, expensive legal wrangling with an administrator over data access fees, which only delays collection efforts further.
The third piece is about internal capabilities. We know that immediate reconciliation is vital. That effort is made so much easier if the agency has been providing management information, or MI. That's genuinely robust. What does robust MI actually look like here?
Robust MI is much more than a summary dashboard showing total cash collected. It requires the agency to provide detailed account-level statements, often in a raw data format, that let the creditor verify the status of every single open account without having to log into the agency system.
So, real granular data.
For example, the MI should include fields detailing the last 5 actions taken on the account, the exact date of the last payment, whether the account has a CONC vulnerability flag and why, the outcome of the last dispute, and the principal versus interest breakdown.
And with that data,
With that granular data, the creditor's internal compliance team can run a simple, automated script to verify the accuracy of the entire £20 million portfolio within hours, not weeks. If you can't run that verification script instantly, your MI is inadequate for crisis management.
and the final component is regulatory assurance. Creditors can't just assume their partner is compliant, especially if they're collecting regulated consumer debt under CONC.
You can't.
So what specific regulatory proofs should be in the playbook?
First, the creditor must demand initial and ongoing proof of the agency's exact FCA permissions. Just being FCA registered is not enough.
You need to see the specifics.
The agency must have the specific permissions required for activities like debt administration or debt collection related to consumer credit. These permissions are nuanced, and if the agency is operating outside its scope, every collection action they take is invalid. It immediately compromises the asset.
And the second part of that.
Second, the regulatory approach has to be contractually aligned with the creditor's own compliance standards. The playbook should require the agency to submit to annual independent audits to verify their systems and staff training align perfectly with evolving CONC requirements, especially around vulnerability and fair treatment.
So you're building a compliant process from the start.
It ensures that when the new firm, Redwood, inherits those 3,725 debtors, they aren't starting their compliance from scratch. They're just continuing a predefined compliant process that the original creditor demanded be followed from day one.
It seems like integrating those 4 steps, data escrow, contractual clarity, robust MI, and regulatory alignment, really reduces the risk.
It drastically reduces the risk premium of outsourcing. It transforms the potential catastrophe of an agency collapse into a manageable, albeit complex, data transfer and legal transition. The transfer of £20 million in collection rights from Scott and Mears to Redwood Collections really serves as a powerful operational case study. It just confirms that debt portfolios, while they seem abstract, are complex assets. They require a robust legal and operational scaffolding to protect them, regardless of the collection agency's stability.
And the value is tied directly to the data.
The preservation of value through this administration hinged entirely on the ability to transfer clean, compliant, and well-documented data. Where that documentation is compromised, where vulnerability flags are lost or legal notices are delayed, the asset value just evaporates.
Making the crisis disproportionately expensive and complicated for the original creditor.
Exactly.
So whether you're a finance director managing outsourcing risk, or you are one of the thousands of individuals impacted by a transfer like this, the central mandate is clarity.
Clarity is everything.
Creditors have to implement playbooks that mandate ledger reconciliation, document security, and that verifiable legal certainty through proper notices of assignment. And debtors, in turn, have to demand detailed balance breakdowns and clear confirmation of legal authority before they part with any money. This whole situation required a complex, costly coordination between administrators, lawyers, and the acquiring agency, Redwood Collections, just to transition the collection efforts.
Huge effort.
Which forces us to ask a final question. Given the inherent operational expense that's associated with recreating, verifying, and compliantly transferring a complex ledger during an administration crisis, how should a creditor truly quantify the hidden risk premium of outsourcing their recovery operations in the first place? That often overlooked operational continuity cost is the true cost of third-party reliance.